The whole house expects a son to, become a man after his father.
Oh my God.
It's
So
a
what is
tedious process. He was 63.
Hmm.
He was perfectly fine. He did not have any ailment which was impending. He did have lifestyle conditions, but he was just gone in a whiff.
Ha.
About 1,50,000 crores of unclaimed assets in India.
Wow.
See, the beauty of a document like a will is that the law doesn't prescribe a format.
They actually forcefully got him to cancel his term insurance. They're saying you can't be thinking negative in life.
Hi. Today we're going to talk about the inevitable. Something that's bound to weigh down on all of us. It's deeply personal but equally important. And that is why it is essential to discuss it today on Actually Speaking. And the topic is grief, death, and the paperwork that follows. Rupinder, hi.
Hi.
Very recently you told me something that affected me very, very deeply. I want you to tell our viewers about it and how emotionally you went through it.
Maddie, my father passed away almost 10 years.
My apologies.
Thank you. Also, at that time, while I was grieving, and the whole family was, I took upon the responsibility to get all the assets transferred. Even though my father was a lawyer and he practiced after his retirement from a government service, it was the unexpected that we thought he didn't leave any will behind. We did not have any conversation regarding any of the assets that he had. While we were grieving, I took upon the responsibility to get all the assets transferred. I took that responsibility also to shy away from the grief.
Of course.
And also channel my energies to get all the assets transferred as a distraction. The whole house expects a son to become a man after his father. Let me tell you, getting all the assets transferred from your father in your family, it's the worst way of becoming a man.
Oh my God.
It's
So
a
what is
tedious process, it's a lengthier process,
And it's a thankless one.
and it's a thankless one.
What you said hit me really hard that, you got into the job at hand also to get over the grief of losing your father. How old was he?
He was 63. He was perfectly fine. He did not have any ailment which was impending. He did have lifestyle conditions, but he was just gone in a whiff.
Wow.
An evening's hospitalization, and during the night he passed away. He did not have the time to even have a constructive conversation with any of us to say that he had a will, where all his assets were. He had a will. We found it out almost 2 months later when everything was done.
Oh my God.
And, he also had a diary to, state all the assets that he had. But there was no conversation ever within the family while he was alive that there is some paperwork that he's kept for all of us.
हमारे दर्शकों को ये समझना ज़रूरी है कि जबकि एक इंसान ने अपनी सारी जिम्मेदारी पूरी करके अपने आने वाले टाइम के लिए तैयारी करके और अपने बच्चों के लिए अपनी जायदाद को किस तरीके से डिस्ट्रीब्यूट करना है उन्होंने ये लिख भी दिया था, पर सिर्फ इस चीज़ को लेकर कि हम एक दूसरे से बात नहीं करते कि हमारे देहांत के बाद क्या होगा, उसकी वजह से जो तकलीफ भूपेंद्र को हुई है उसके बारे में हम चर्चा कर रहे हैं. एंड वो आप कह रहे थे कि लॉयर भी हैं और इसीलिए जाहिर है कि वो लीगली उन्होंने सब कुछ किया होगा, पर जो कि आपने बात नहीं की, आपको इतनी सारी तकलीफें उठानी पड़ी उनके एसेट्स को डिस्पर्स करने में, और फिर वो आपको लीगली करना होगा, कोर्ट में गए होंगे.
कोर्ट में, so and at the same time this process is very cumbersome. Private banks for a bank account is as good as a PSU bank, is as good as a court.
अरे बाप रे.
In absence of a will, there is a tedious process, and God forbid if there is a dispute in the family.
Correct.
Then it takes years. Luckily for us, we did not have any such dispute, and all our assets went to our mother after my father.
That's what you all decided.
Yes, and that was there in the will as well.
Thankfully.
Which was found later. We were lucky, but God forbid if there is a dispute, it can go on for years and years.
Oh my God. And on a time like this, when you're grieving, also there is anger, there's emotional outbursts. At a time like that, you need to have a structure which is unquestionable. Am I right? Which I think brings me to the next part and introduction to our next guest, Nikhil. Thank you for taking time to join us. Could you tell us a little about what you do and why you do it?
No, it's great to have this conversation with you, right? And a very interesting story that Rupinder mentioned, and there's something I've heard multiple times. I started my career as a CA, did good amount of work with two of the big fours, and thereafter shifted entire tangent to say how do you help families with estate planning, right? There's only very few who are actually practicing estate planning in India, very niche space, and therefore the concentration is with the HNIs, ultra HNIs, so that because the numbers are good, you're doing well from that perspective. But when you look at the stark contrast that you have to see in terms of the hygiene here with respect to the kind of how many people write a will or create their estate plan in India versus look at it in the West. A simple example would be, say, US, more than 50% of the adults have done their, if not an advanced estate plan, right? In India, there's no real numbers. My estimate would be in lower single digit numbers.
Oh my God.
So, therefore, there's a huge gap, right? And why all of those will come to it later. But that was the trigger point to say, how do we kind of take this to the mass market? And that's where me and my co-founder started Yellow to kind of democratize the whole will creation process for everyone, bring that basic financial hygiene for family so that situations like these don't arise. Families have complete visibility of what assets one owns, and therefore you don't need to run behind. And why this is also there's a huge, these numbers are doing good amount of rounds, about 1,50,000 crores of unclaimed assets in India.
Wow.
Again, stemming from the fact that when one passes away, does family know about these assets?
Yeah.
Right? And a simple example, again, the audience will also relate to this, is that if you ask your spouse or your family, how sure are you about the assets that I own? Does my wife have complete clarity about it? Many a scenario, right? More than 90%, I can stick my neck out and say they'll have no clue or maybe some clue. Another interesting fact would be to say that would you have complete visibility of all your assets? That is also a situation where you don't have complete visibility, right? And therefore, how do you kind of put together those financial hygiene in places where Yellow kind of came into the picture for us?
So the name of the service you provide is called Yellow.
Yeah.
And in synopsis, what does Yellow actually do?
We basically kind of lift the entire traditional way of will making and make it something similar, something seamless for family wherein you can get your will done at your comfort of your home.
Lovely.
Right? You don't need lawyers. You don't need, See, the beauty of a document like a will is that the law doesn't prescribe a format. Law doesn't say that somebody so and so qualification are required to kind of draft this. You can do it on your own. A simple one pager saying all my assets goes to my spouse is a valid document, right? But still, it needs to have this robustness. And how do you build that robustness is something that we have kind of put together in a platform to help Indians kind of get it done at the comfort of their home without need to go to lawyers, spend good amount of time, and also burn the pocket in terms
And the
of
fact that
expenses.
it's legally valid as well.
100%.
Yeah, great. So it's true what you say. We want to do the best for our families, but because of our inability to talk about their life after our death, we end up causing more trouble at a time we're not around to fix it. And that's what we were talking about. So let's start with, why do the people not want to talk about it in the first place? Like I can see that, हमारे यहाँ, at least हमारे शास्त्र में कहा जाता है कि शुभ शुभ बोलो, बुरी चीज़ों के बारे में बात मत करो. But sometimes it's very important to talk about. इसको कहते हैं कि let's talk about the future at least.
Sure.
Without making it sound morbid.
Yeah. No, so I'll actually go back to the your previous episode where you spoke about saying when you wrote your will, it was as if you're signing a death warrant.
Correct.
Right? That's the mentality in India.
Correct.
Right? And again, it also kind of stems from the fact that how we have brought up. Right? We're pretty much guarded with the family. You're always you're not let loose to say, hey, go get your stuffs done, right? Unlike in the West, if you look at people at the age of 15, 16 are asked to leave, figure your stuff, and therefore you kind of acclimatize to be independent, and they're open about talking about all these things. In India, it's the same thing about getting your will done, getting your insurance done. like, why are we talking about this? Are we inviting death?
Correct.
That's the simple mentality that Indian families kind of come with. And
So I have a similar example. So one of my friends in the insurance industry has been in insurance for almost 15, 20 years, bought a term insurance. And as soon as he went back and told his family was like, you're thinking about death.
Correct.
Something is about to happen to you. They actually forcefully got him to cancel his term insurance. They're saying you can't be thinking negative in life. Such is the thought process in our country, and it happens to most of the sophisticated people as well.
Correct.
People who have an understanding around financial products like term insurance, for that matter. Such things happen. It's a very cultural thing.
In fact, I've had conversations with families जहाँ पे लोग कहते हैं कि अरे इसमें लिखने की क्या बात है, बेटी की आप दहेज दे के शादी कराते हो धूमधाम से, बेटे को आप पढ़ाते हो, बुढ़ापे में बेटा अपना ख्याल रखता है, सारा जायदाद तो बेटे को ही जाएगा, अब इसको लिख के बताने की क्या जरूरत है. बट आप लोग समझें कि इसको लिख के बताने की बहुत सख्त ज़रूरत है, क्योंकि लॉज के बारे में आपको नहीं पता, जो लेटेस्ट कोर्ट रूलिंग्स है उसके बारे में आपको नहीं पता, और इसके लिए अपने जायदाद को किस तरीके से, किस वक्त और किस स्टेजेस में आप अपने संतानों को या अपने चाहने वालों को लिख के देते हैं, इसके बारे में आपको जानकारी होना बहुत ज़रूरी है. वरना पता चला कि आप उनको जायदाद देने के बदले में आपने उनको कर्ज कर दिया. और इससे बचने के लिए हमें क्या करना है, इसके बारे में हम निखिल से बात करेंगे. निखिल, प्लीज टेल मी, कैन यू गिव मी एन ओवरव्यू ऑफ व्हाट हैपेंस व्हेन अ पेरेंट और अ क्लोज रिलेटिव और गॉड फॉरबिड अ स्पाउस passes away? What are the things that you need to do?
see, it's a maze, right, in India when you have to get to this situation on what needs to be done with respect to getting those asset transmission to be done, right, when a loved one passes away, because already you're grieving. And beyond that, you need to kind of handle these humongous tasks because everybody's not equipped to kind of run this. You need to run pillar to post. The whole process is cumbersome with so much aspects in digital
Correct.
digital space today in India. Anything to do with asset transfer is fully manual. The claim forms are different. You have to look at a permutation and combination of situations, right? Do you have a will? Do you not have a will? If you don't have a will, you have nomination. Don't have nomination. Every form is different. And what we have understood from the overall conversation from various institutions is that one of the biggest or the largest reason for claim rejections is your forms are going incorrectly formed.
The forms are incorrectly filled.
Correct.
So who's going to teach them how to fill up the forms correctly? मतलब you expect कि form है, the questions will be straightforward. नाम क्या है, surname क्या है, age क्या है, वही होगा.
No.
How can you incorrectly fill a form?
So it so happens, right? It's when I say incorrectly, it's more about to say that what are you filling in there, because it's not so easy.
Right.
You also have various attachments to come in. Now this again, just stepping back, right? Why there's so much urgency here is more for the fact that especially when you don't have a will in place, right? The kind of documentation is what you need is different across jurisdiction, because India is a country where things are different across, because of the way the whole situations are around. For instance, the kind of document that is needed, you need a succession certificate, inheritance certificate, pedi nama, letter of administration. These are documents that is different depending on the jurisdiction. For instance, succession certificate is something that I'm talking about is, say, relevant for Karnataka, right? In Bombay, when it come down to, it's a letter of administration that is needed from the High Court. We get a family tree which is from the municipality, right? Now, if you look at kind of assets, in some jurisdictions, a family tree is good enough for real estate, but a succession certificate is required for movable assets.
Oh boy.
Right? And now, taking a step ahead, each financial institutions have their own thresholds. PSUs, at 1 rupee also they say I need a succession certificate. Obtaining that, it's a cost by itself, time by itself. And other institutions say at about 2 lakh, 3 lakh, etc. They put a benchmark. Until then, an affidavit will kind of do the job. Otherwise, you need to provide the succession certificate. The reason I'm highlighting all of it is that before you even get to the transfer process, you need to get certain documents in place to kind of ensure that the transfer process itself can happen, right? And that itself can take at least 6 months, if not more.
Wow.
Then you get to the process of taking these documentation along with death certificate, etc., to go to each financial institution sub-registrar to kind of ensure the asset transfer happens. which in our experience, we have seen that bare minimum on an average, it'll be about 3 years. God forbid there's a litigation, it can go to 10, 15 years, and
Oh,
that's something which can go on. And we have seen this ample number of cases which is
you know, you've got my attention right now simply because I'm wondering what I'm doing wrong, because I haven't even heard of the things that you're telling me right
Yeah.
now. I thought my job is done after I've written the will. That is not correct. So, as an individual who's passing on his wealth to his offsprings, what are the things I need to do so that I don't make their life miserable? You know, well, there's nothing more irritating to say, hey, that money belongs to me, but I can't get it because the bank is sitting on it.
Correct. No, so having a will in place really streamlines this entire process.
It does.
Right? It does.
Okay,
It's
so then
not
you
that-
don't need a succession certificate.
No, you
and
don't
stuff?
need all of those.
That's what I'm saying. So,
Absolutely.
ताकि आप समझ जाएं कि जो निखिल ये कह रहे हैं कि अगर आपके पास विल न हो, अगर आपने ये विल नहीं लिखा है या आपके पास इसकी कॉपी नहीं है या आपके पास ये एग्जीक्यूटर नहीं है, तो ये सारी तकलीफें आपको फेस करने की पूरी मतलब शक्यता है. तो you have to remember that a well written, clear, explicit will actually end up achieving what you have in mind for the sake of your offspring. Okay, so would you say that a will is like a map or a guidebook that has all these details for your family?
Absolutely, right. For us, will is not essentially, if I have to relook at it differently, will is a means to ensure family gets these access, right? Like I initially said, you can have a one-pager to say all my assets goes to my spouse. Is it legally valid? Answer is yes, it's
Yes, it
legally
is.
valid.
Okay.
Is it relevant? Answer is no. Now the spouse needs to understand saying what are these assets,
Understood.
right? So therefore, having a will in place which also encapsulates all the assets, not by values but at least by identifiers, right? I have an HDFC bank account, say HDFC bank account number so and so. I don't need to talk about values, I don't need to talk about anything else. Basically, having that map or an asset register, as we call it, gives the family the entire details of what the assets. Now they know what asset needs to be chased for, rather than going in the dark, right?
Which generally in Indian families is a lal kitab. It's a diary, right? Stacked up somewhere in the cupboard. Nobody knows about it.
You know, a terminology you just used. What was it? The asset, what is it?
Asset register.
करेक्ट. सो ये आपको जानना ज़रूरी है कि सिर्फ विल लिखना ही काफ़ी नहीं है, क्योंकि अगर आपने लिख दिया कि मेरी सारी पूंजी और जायदाद जो है ये मेरी बीवी को जाएगी या मेरे बच्चे को, उनको पता तो होना चाहिए कि आपके पास है क्या और है कहाँ. एंड दैट इज़ वाई दिस asset register is very important. I think for educated, I don't have an asset register, and I'm going to go make sure that I don't complicate the lives for people by making sure that उस asset register में आपके क्या क्या जायदाद हैं, कौन सा मूवेबल एसेट है, कौन से बैंक में अकाउंट है, अकाउंट नंबर क्या है. आपको उसके वैल्यू लिखने की जरूरत नहीं है, अमाउंट लिखने की जरूरत नहीं है, पर कम से कम लोगों को पता तो चले कि किस बैंक के पास जाए और किस अकाउंट के बारे में बात करें, किस इलाके में जाए और किस घर के बारे में बात करें, कौन सी गाड़ी आपकी है, किस में उस पर कोई लोन है या नहीं, लोन भर दिया गया है या नहीं. ये सारे अगर संक्षेप में आप लिख दें अपने बिल के साथ और उसको ऐड कर दें और उसको भी स्टैम्प करवा दें, तो फिर वाकई में आपकी ब्लेसिंग जो वो ब्लेसिंग है और रहेगी. But it all feels a little complicated, Nikhil, to be honest, okay, for the common man. I understand जो बोल रहे हो, don't you think? So, drafting sounds pretty complex. How can we make it simple for them to understand?
See, very honestly, it's not complex. Like I said, you don't need any ideal ways to look at a professional and get it done. But actually, you can do it at your home, right? All that, what are we talking about in a will is that basically, who am I? What are my assets? Who are my family members? How these assets needs to be distributed. It's as simple as that.
Okay.
Get it in place, have it, you need to physically sign it along with 2 witnesses. It's a legally valid document.
Wonderful.
It's not very complex, right?
You don't have to get a stamp paper and go to the court and all that.
Nothing of those sort, right? You're just another example. There is age-old case law where a farmer had written his will on the bonnet of his tractor and it was taken as legally valid and accepted, right? Oral wills are accepted in certain scenarios. There's more so it's called as privileged will, more relevant for our army jawans and whatnot, right? So there are many various categories. For common man in India, you need to have a physical will signed along with 2 witnesses, and that becomes a legally valid document. But it's not a complex process. All that you need to do is capture your life situation. That's it, right? Like you rightly said, don't need to go to court, don't need to get a stamp paper. Registration is an optional aspect. There's something that we usually get questions saying, do I need to register my will? I usually tell my customers saying that no, you may look at registering it. It's a benefit by itself, but specifically when you have real estate, it's good to have your will registered because that eases the process for the family with respect to asset transfer for real estate.
वेरी गुड.
Right? Otherwise, there's nothing. It's not complex at all. You can do it at the comfort of your home.
तो आप समझ लीजिए कि आपको ना ही कोर्ट के पास जाने की ज़रूरत है, ना कोई लॉयर की ज़रूरत है, ना कोई एक्सपर्ट की ज़रूरत है, जो आपको, हालांकि वो आपकी मदद कर सकते हैं, पर अगर आप अपनी इच्छाओं को एक पेपर में स्पष्ट तरीके से लिख दें और ये लिख दें कि आपके पास कौन से एसेट हैं, कहाँ पे हैं और किसको जा रहा है, वही एक, और उसे माफ़ कीजिएगा, और उसे साइन करते वक्त 2 विटनेस के साथ उसको साइन कराएं, वो एक वैलिड डॉक्यूमेंट है. आपको, जैसे कि मैंने कहा, कि स्टैम्प पेपर भी लेने की ज़रूरत नहीं है. और ये आपको करना ज़रूरी है. और इसके बाद हम 3 चीज़ के बारे में बात करेंगे. एक, कि किस उम्र में हमको विल लिख लेना चाहिए. दूसरी ये कि क्या उस विल को हम बदल सकते हैं. और एक और बात मैं आपसे पूछना चाहता हूँ निखिल सर, कि ये आपने बताया था कि हमने बताया था कि एक एग्जीक्यूटर भी चाहिए. ये एग्जीक्यूटर कौन है और इसकी जिम्मेदारी क्या है?
No, great. So, one, if you ask about the age of when should you write a will,
जी.
law says 18 years plus.
ओके.
Law says anybody above the age of 18 can write a will. Now it's a question of saying what could be that right age to, write your will. And usually you push this to the back burner saying, let me write it when I'm really old or when I'm really sick, right? And if you could predict your life saying when you're going to die, you don't need to even write a will. You could have gifted it to your family and
Correct.
moved on, right?
Correct.
Life is uncertain, and that's why these documents become very important. And therefore, anybody who has even a simple bank account should be looking at writing a will. It's as simple as from the age perspective. That could be when you start your first job. Even today, everybody has a bank account. You need that to be transferred. Get it in place. So once you write your will in place, you can change it every minute. Right? There's no restriction on how many times can you change it. But practically, if you look at it, what and when one should look at changing, updating your will is that at least once in a year, go back and see, is there a change in your either your family scenario or your asset scenario. If there's a substantial change, go back and amend it, update it. But if you've not done that, at least you're very sure that you've actually looked at your will that is already in place, and you're pretty much sure that nothing needs to be done. At least you're in your mind, you have peace of mind.
You just have to update the asset register.
Asset register to that extent. See, again, if you look at financial assets, that's a little bit more dynamic because it keeps changing. There are good tips to look at. Unless you're going to specificity to say, have shares in Tata, I have shares in Reliance, needs to go to son one. Reliance needs to go to daughter. If that is the kind of detailing that you're going down to, then probably you need to get into looking at it very often, right? But typically, if you see, like Rupinder said, most of the scenarios, the assets are, the wishes are more or less to say all my assets goes to my spouse.
Yeah.
Now it's only identification that I need. I don't need to get into what under my demat account, what shares are there.
I understand. But they also say after her or him, it has to go to the
Exactly.
son. And
That's
that
the
bifurcation-
contingency planning.
Contingency plan, that also has to, because or she's
100%.
allowed to do what she has to do.
100%.
That is very important.
And I can share a case of another client of mine, right, where he was in the US. His parents, though they wrote the will, they said all my assets goes to my spouse and vice versa, had a decent will in place, but they didn't talk about this contingency.
Correct.
Unfortunately, both passed in quick succession, and now my client has moved to Bangalore to kind of figure out his stuff with respect to the family's assets, but it's as good as no will in place.
नो विल इन प्लेस. ये एक बहुत ज़रूरी है कि कुछ लोग लिख देते हैं कि ये मेरी बीवी को जाएगा या जो मेरी एसेट है मेरे पति को जाएगा, पर उसके बाद क्या, कभी कभी हो सकता है कि एक दुर्घटना में दोनों की देहांत हो जाए, फिर उसके बाद ऐसा ही सिनेरियो होगा कि आपने किसी के लिए विल नहीं लिखा हो.
Correct.
और एक सवाल मैं पूछना चाह रहा हूँ, आई थिंक कुछ लोगों को ये भी नहीं पता कि एसेट है क्या. जैसे कि टर्म इंश्योरेंस भी एक एसेट है,
Yeah.
लाइफ इंश्योरेंस एक एसेट है, आपके गहने एसेट्स हैं,
Correct.
आपके घर, बंगले, गाड़ी, कभी कभी तो मैं कहता हूँ, मैंने लोगों को देखा हथियार जो बचपन से उनके यहाँ पे वो 100 साल से उनके यहाँ कोई ब्रिटिश वेपन है, ये सब जो एंटीक चीज़ें हैं, ये भी एसेट्स माने जाते हैं.
Royalty for content creators.
रॉयल्टी फॉर कंटेंट क्रिएटर्स, इसके बारे में लोग नहीं पता. आजकल कंटेंट क्रिएटर्स के जो एसेट है वो पता ही नहीं कि कैसा किया जाए.
So it's the content is there and it'll keep giving you a revenue.
सोशल मीडिया से जो रेवेन्यू आती है उसके बारे में लोगों को नहीं पता कि वो भी एक एसेट हो सकता है
Correct.
लाइफ लॉन्ग वाला. देयर आर सो मेनी थिंग्स.
Absolutely.
How do you make a checklist for this? What I'm trying to say is, your situation in today's world keeps changing, right? So, is there a format or a checklist or a place that I can go to which categorizes ki, do you have anything in this category? Do you have anything in this category? So that it becomes easy for the guy to remember all his assets and put it in one place.
This will end up me promoting the app, but if you go to our platform, we have kind of broken down into 40 plus asset categories to say these are the assets.
No, I think that's very helpful. It's
Yeah.
not just promoting. I'm saying an educated person like me, I did not know till now
Yeah.
that there should be an asset register, which is actually making sense right now.
Correct.
And in the, the nervousness of writing your will, which, like I said, makes you feel like you're writing a death warrant.
Correct.
You forget what to do. And
Yeah.
I think you need to be lucid and clear about your intent.
Exactly.
You need to be very sure of contingency plans. If you and your wife were to, not be around,
Correct.
then what happens after that? Who does it go to? And
Absolutely.
most importantly, who are the two witnesses signing it?
Correct.
And let's come to the executor.
So, executor is the person who actually gives effect to the will, right? You're not around, but your wishes needs to be given effect to. That's the role of the executor, right? Now, multiple schools of thought saying who should be the executor, should it be a beneficiary, should it not be a beneficiary? Simple answer is that law doesn't restrict a beneficiary to be an executor. In very, if you look at Indian consumers and at least the kind of consumers that we are looking at least from my company's perspective, we are looking at nuclear families, right? In nuclear families, the wishes are again very simple to say all my assets goes to my spouse in most scenarios. Maybe spouse plus certain portion of it to children, but most scenarios, all my assets goes to my spouse. In that case, spouse being the executor is a good fact pattern to have. But if you look at larger joint families where wishes are very complex, where asset needs to go to spouse, mother, siblings, kids, in that case, having an independent executor really helps, because then you're not having a, the executor should not be in a situation of going rogue, right? To kind of saying how the asset needs to be distributed, and if there are multiple players, you don't want them to question saying they are not acting in right faith.
So I'm an executor for one of my friends' will. I think it becomes really, really important if you can foresee a conflict in the family after your death. Like my friend expects a dispute between his spouse and children against his family. They ran away and had a marriage. The family never accepted. There is going to be a dispute that he expects, and hence he's made two of his friends as witnesses who are independent, do not have a conflict of interest, and me being the executor of the will, so that somebody independent can execute their wishes after they are gone.
Correct.
If the witness, the beneficiary, and the executor are intermingled, there is a chance that the dispute can actually go on the other side, which may be against your wish altogether.
On that note, sometimes witness plays an extremely important role in a will, right? Why? So, because if the will gets contested, witness is the one who's going to testify before court to say, I've seen this person sign this will in my presence, right? Many a times we have seen families kind of take this role very, not so important and keep it to say, let my driver or my house help be the witness. That's the worst move to do in a will.
Very, very important.
Right?
The witness is very important when you write your will. Yes, समझ लीजिए कोई driver, assistant या domestic help सब लिखवा देते हैं and they are not around to.
Because that's a practice that we have for any document, right? Say, hey, come here, be the witness.
What is exactly, and that is not good.
Absolutely not for a will.
So comes to the next question that I think is very relevant. Does the executor of your will need to know the content of the will?
Both executor and witness need not know the content. Executor, see, good point that you highlighted. Should executor know the existence of the will?
Yes.
Is also another question, right? Very honestly, you should let the executor know for two reasons. One is that you are appointing so-and-so person as an executor. Now his friend has appointed him as an executor. Good fact is that he knows about it. If I were to appoint Rupinder as an executor, tomorrow what if Rupinder says, I don't want to take up this role?
Correct.
right?
There's a possibility.
And it has happened.
Huh.
It does happen for two, three reasons, right? One, he may not be around.
Exactly.
He may move to, say, US and he's staying there. Why would
That
he
was
do
my
the
next
work here?
question.
Right? And the third scenario could be, you could just say, I don't want to take this responsibility on me and therefore I don't want to do it. Right? And therefore, having that conversation with the executor to say, hey, are you willing to take up this role? This is a very important role for me. Are you willing to take it up? And that consent has to come, whether formally, informally, but have that conversation. And yeah.
And the family needs to know that such an executor exists?
Family does need to know because they'll see it in the will.
No, but okay, understood.
Obviously, it's kind of written there. But going back to your point, does the executor need to know the content of the will? Answer is no.
No.
Does the witness need to know the content of the will? The answer is no. Witness just need to testify before the court that I've seen XYZ sign this will in my presence. That's it.
तो विटनेस की जिम्मेदारी सिर्फ ये है कि भाई मैंने अपने आंखों के सामने इसको साइन करते हुए देखा, वो बताना जरूरी है. तो ऐसे लोगों से विटनेस बनाइए जिनको आपको लगता है कि वो रहेंगे और आपकी बातों के साथ वो सहमत रहेंगे इन टर्म्स ऑफ द फैक्ट कि आपने मतलब तहे दिल से और सही दिमाग से आपने वो विल साइन किया है. विल के एग्जीक्यूटर और विटनेस को आपके जायदाद के बारे में जानना ज़रूरी नहीं है, बिल्कुल ज़रूरी नहीं है, और उनको ये भी नहीं जानना ज़रूरी है कि आपके बिल में आपने क्या लिखा है और किसके लिए लिखा है. पर सवाल मैं पूछना चाहता हूँ कि अगर वो एग्जीक्यूटर ही नहीं रहा, क्योंकि वो भी अनॉमली होता है एक, तो फिर क्या होता है?
Contingency planning again.
हाँ.
Like how you are looking at contingency planning for your beneficiaries, you can have line
You can have multiple executors?
100%. You can have a combination of joint or individual executors with a priority of list, right? My preference is usually to have one executor because you don't want too many people. Too many people now need to
So
sign.
what is the executor's responsibility?
Basically,
इसको करना क्या है?
If I were to put it, bare bones, if I write a will, if I'm not around, say I made Rupinder as my executor to the will, he has to now sign every document with respect to asset transfer.
Oh.
He takes a responsibility to say that Nikhil's wish was to say asset needs to be distributed in so and so fashion, and now he gives effect to those wishes.
Gives effect मतलब उसको उस जायदाद के ट्रांसफर में इनका सिग्नेचर देना जरूरी है.
And he has to ensure that transfer happens that way.
तो इस सवाल में यही पूछ रहा हूँ कि आपको मल्टीपल एग्जीक्यूटर्स होना जरूरी है, क्योंकि अगर एक नहीं रहा और वो बिल रहा है और फिर आप फंस गए क्योंकि वो एग्जीक्यूटर नहीं साइन कर रहा है.
If you have one executor and if the executor is no more, then the family needs to go to the court to appoint a new executor to do it.
Right? And the executor cannot hold the family to ransom. Is there a possible? But the reason I'm asking is, suppose the executor knows, and I'm saying it's a drama from a film. I'm a filming guy, so let me give you a filmy scenario.
Sure.
यार मैं निखिल ने मेरे को तो एग्जीक्यूटर बना दिया, मेरी लाइफ में हालत खराब हो गई, मेरे को इतने चीज़ें पता चला निखिल के पास कुछ 300 करोड़ रुपए हैं, उसको डिस्ट्रीब्यूट करना है. मैं कह रहा हूँ या मेरे मतलब तो और मैं कहता हूँ भाई तुमको 300 करोड़ मिल रहा है, पहले मेरे को 30 दे दो फिर मैं साइन करता हूँ. ऐसा हो सकता है?
Possible.
मैं कह रहा हूँ.
What could happen is that executor now can dilly-dally with respect to the whole transfer process.
What I'm saying is, so be very, very careful who your executor is. It is not anybody or random कि आप शैम्पू दारू पीते हुए आपने किसी को executor बना दिया. हो सकता है कि ये आपको वापस काटने को आ जाए, which I don't think anybody has talked about.
Absolutely. Executor and witness should be someone who you really trust, and who you think will stand up for your family when you're not around.
Exactly.
But is it important to have an executor?
100%.
I mean, what happens if there is no executor in the will?
Court will now have to appoint an executor.
But it's not a complicated process.
You still have to go to court, right? Now you know the backlogs in the court. This process is going to delay. See, when your family, especially when there's single breadwinner who is not around, family needs immediate access to these assets, and these are delaying the whole process.
So executor होना बहुत जरूरी है. It's very important to have that person who you think will be a reflection of your ideas and ideologies, so that there is no conflict in the family, between the family, the executor, as well as the legalities. So it feels like your family dynamics are complex. Like my kids are fighting, or they are not getting along with my partner. Maybe there is more than one partner involved. Then there is all the more reason to write a will. But what happens when there is no will, which is what we just discussed? Do the legal heirs get everything equally? Is that how it's distributed?
Unfortunately, no. Right. This goes back to a situation in legal terms. It's called as intestate succession. Basically, you have not done your will or put an estate plan in place. Therefore, the law now assumes various parameters basis which the asset needs to be transferred. It's an archaic law, close to 100 years old.
Baapre.
Created then with the cultural mindset then, right? I'll give you an example around all of these. Basically, the Indian succession law now defines how the asset needs to be transferred, basis religion, basis gender. There's a specific metrics that has been stated.
Oh, really?
Yeah.
So can you enlighten us on that aspect of it?
Simple
Like,
example, right?
how
So
can you explain that?
So for a Hindu male, if you don't write a will, the class 1 heir is essentially a mother, spouse, and children. All get equal share,
Okay.
right? Your wish may not be that, right? If your wish is that, then that's fine, right? For a Hindu female, spouse and children are class 1 heir. If it's self-acquired asset and God forbid spouse and children are not around, it goes to in-laws before even it goes to your own parents,
Oi.
right? That's how see, because that time
I'm not saying that out of any experience. I'm just saying I didn't know.
so the point being that the law was constructed then saying that when the girl is married, she's gone to that family, everything belongs to that family, right? So it's with that traditional mindset is where the law is. It's not amended, and unfortunately there's some amendments that has happened in 2005 which now gives the girl the power to have equal right in parents' properties, right? That amendment happened only in 2005 from 1925, right? So therefore, basis religion, I gave an example for Hindus. For Muslims, you can only write 1/3 of your property on a will. The rest 2/3 has to go by your religious law, unless you get NOCs from all legal heirs, right? For Christians, it's 1/3 to spouse, 2/3 to children. Basically, what I'm coming to is that for each religion, each gender, there is a way in which the law prescribes how the asset needs to be
Which may
distributed.
not be in tandem with what you have in mind.
It may not be a wish. My wish could be very simple to say all my asset needs to go to my spouse.
Correct.
But if I don't write, it'll go to my mother, it'll go to my children. Is that what you want? And more importantly for children, sorry Rupesh, I'll come to that. Children at the age of 18 getting few crores of rupees is can be a disaster.
Correct. We
Right?
just discussed that in the talk before this.
So this is exactly what happened with us as a family. We did not have a dispute. All the assets were to go to my mother. My brother and I, and my brother stays in US, we had to write affidavits for every asset to declare as an NOC that we don't have a problem, all the assets going to my mother.
Okay.
Every bank account, every demat account, every asset, whether it is financial or immovable, you have to go to the court to write different affidavits.
It's a lifelong process.
It is.
Going back to your point, classic case is, Dhirubhai Ambani. He didn't write his will.
Oh, he didn't.
He didn't, right? And that's why the both brothers fought. Now, that's a public news. You know how the asset distribution thereafter happened, which could have been very simple if he had written a will saying these businesses goes to son 1, these businesses go to son 2. It would have been very clear. Of course, can they still contest the will? Answer is yes. We'll talk about it maybe subsequently in terms of what are the scenarios. But coming back to the point is that it can if you don't write a will, obviously there can be family disputes, right? Because when you write a will, you're actually giving clear intentions of what your assets are.
Correct.
And how these assets needs to be distributed. As long as it's in black and white, not in shades of gray, there's no reason for someone to debate or even look at unambiguous situations to understand saying, is there something that I need to interpret here?
Correct.
And it need not be so. If you're writing in plain language saying my property 1 goes to son and property 2 goes to daughter, what is the reason for you to debate here? It's as simple as putting in black and white, right?
Correct.
So as long as your document is, if you're writing it in such clear terms to say clear terms in terms of keeping it fully in no ambiguity, black and white, that kind of takes away any litigation or a probability. But if you don't write it, obviously now you're left to thinking saying how these assets needs to be transferred. And then there are scenarios of someone popping up and saying, listen, I was promised so and so asset. This property, this parcel was belonging to me. I was taking care of this parcel of property, and we've seen this in agriculture land.
We've heard
I've
all
been
this
doing
stuff.
all these, and therefore this should be my asset,
Correct.
right? All those confusions come in, and obviously it's a reason for a family dispute.
So I know that there's a lot of trouble when I don't write a will, but can I assume that once I write a will, everything will be sorted out?
How do I answer this, right? So the funny part in India is that every document can be litigated. right? So even a will can be litigated. Bal Thackeray's will got litigated. He had the best of the fact patterns to have his doctor and the lawyer as his witnesses. That's the best fact pattern to have in a witness, because you're saying the doctor is saying, witnessing, saying that he is of sound mind.
Yeah.
The lawyer is the one who is actually getting the whole things in place. But having said that, it still got litigated. But of course, it got settled in well, because as long as it's a robust will, you can come back to the situation where you actually your wishes are given effect to.
Correct.
But it can get litigated, and that's something which you can't avoid.
Understand. So as long as you make the will clear, lucid, and explicit with what you're saying, there are less troubles.
There are good fact patterns to have in terms of making it robust. As long as those checks and balances are taken care of, even though it gets litigated, you can
The
ensure
outcome is pretty clear.
this. But that said, you want to have a foolproof way of getting this done. You don't want any litigation. You want to ensure that asset needs to go to my family without any delay. The delays of transfer from one individual to the other, and keep it all in a kosher kind of a structure. Trust is a good way to go.
Understood. So on the other hand, if there is no will, and like we were discussing, if the family isn't getting along and it's going to the court to sort it out the only way.
Not really. Even if there's a litigation, court of course is one of the ways of going. And in my experience, I've seen that while they go to court, it goes for 10-15 years and it never closes. Eventually, they come out of the court and do out of court settlement.
Out of court settlement.
And that can even be the starting point for you. Look at an arbitration route or whatever to understand what the family really needs. Can you settle it? That's the best way to go about. I know it's not usually it's not the real asset transfer that is of relevance. It's the ego clash that actually creates the whole big pain of actually settling on saying what needs to happen. After some time, after they're tired of the court battle, is when they come out of the court and say, let's settle it and move on in life, which is something which you need to do in the first instance.
Correct. How long did it take you, Rupinder, to sort out everything?
The district magistrate was our family friend. Still took me a month.
A month.
While we were grieving, you go to all these banks, courts, other places to be able to figure out what all assets are there, how do they need to get transferred. Every banks generally have a similar process, but every asset class has a different process and documentation. So it takes you some bit of time to be able to understand that there is not much data available around what all needs to happen. It varies from state to state. At the same time, nobody really knows anything about it. So even if you may have elders around within the family, nobody's done it in their lifetime.
Yeah.
And at the same time, nobody knows better.
Correct.
So you got to go and figure it out yourself. You will be in that state of mind, but at the same time, the bank guy will say, oh, this person is not there today. Please come back tomorrow.
Yeah, that I can understand. But 1 month was not such a bad time.
I had it very easy.
Very
I had it
The
very
best
easy.
case scenario.
I had it very easy because there was no dispute. We intended to execute in the same manner what we later found out was in the will.
Wish, yeah.
At the same time, we didn't have to do a lot because in one go itself, we created like 20 affidavits.
Nice.
We were able to scout for all the assets that he had, and at the same time, the process was very fastened. Even though we knew the district magistrate, the tehsildar still expected a bribe.
Oh.
He tried to delay it for almost 10 days, but eventually he understood that there is nothing that he'll make out of it. And yeah, but we really had it easy. But it is painful. The whole process of within that month or two of you going out and trying to do all of this stuff makes you go back, grieve all the more. There are many instances like that. I wish my father had told us about the will.
So now that you've been through the process, what is it that you wish you knew before?
I wish my father had told all of us about the will.
Yeah.
I wish he had told us about all the assets. Even if not us, somebody. He should have told it to some family friend. As a culture, also, we don't talk about it a lot.
Correct.
He had a will, he had an executor, he had witnesses. All of those people were around us for the next 1 month after his death.
Nice.
Nobody even spoke anything that he had a will, even though those people had signed on the will.
Oh.
People don't want to get into the family matters to create a dispute or even come in the limelight.
The will existed.
Yeah.
That is the sounds. See, this really a reason you need to look at saying who should be the executor and witness to your will.
I mean, if you signed it and you're a witness, you still they know you're running around and they just didn't tell you.
No, they didn't want to get into the family matters. They did not want to be the reason that a family dispute started. People just want to remain silent. At the same time, getting nominations done on all your bank accounts, demat accounts, wherever, whichever asset classes allow that.
I think it's become legal now.
Yeah.
Legally, you have to put the nominations there.
See, the funny part here is that India has, I don't recollect the exact number of demat accounts, but more than 70% have opted out.
Oh.
So 30% have actually nominated, 70% have opted out saying, I don't want to nominate. Right? Now, is it a bank opening, wherein you have auto-checked it? Or is it, individuals actually doing it? I don't see a reason individuals actually doing it. But the fact is, that's where it is, right? And therefore, while nomination is extremely important, by the way, nominee is not the legal heir. Nominee is just a trustee to your asset.
Yeah.
Right? Just, again, one of the reasons why Indians don't make will is they assume that I have done nomination for my bank account, what more?
Correct.
Right? Because the nominee is going to get the asset. Why do I need to write a will? But unfortunately, nominee is just a trustee. And we say this many a times that, at least in our field, that in India, or rather across the world, anybody can die only two ways. With a will, without a will. There's no other way you can die, right? And if you die without a will, your nominee doesn't
necessarily
become the legal heir. Nominee still, the responsibility of the nominee is to actually take the asset and now distribute among legal heir, which is either coming through your will or through the Indian succession law, which I spoke about.
Understood. Oh, you should understand the definition of a nominee before you assume what it is.
Yeah, the nominee is just a custodian.
So your bank account will be distributed to
the nominee. To the nominee. Will be distributed to the nominee, but the nominee is required to distribute this to the legal heirs.
Oh, so he just can't walk away with the money.
He can't, right?
Understood.
Why the banks and institutions distribute it to the legal heir? Because they're discharging their liability, because tomorrow nobody should sue them saying, who asked you to give it to so-and-so person?
Correct.
Which can happen, let's say if there is a single parent, their children are underage, you can't really transfer your assets to them. So you'll have to have some custodian, some nominee who may not be the actual person that you want to give your assets to, but they'll be the custodian till the time the children come of age.
To be distributed.
And hence they will get that money.
Understood. So now, I'm sure you also have a list of things where you wish the common man or woman knew so that they could prevent all this heartache happening when the unfortunate incident happens.
Yeah. So some of the things that I actually want to touch upon, right, in terms of, while we are talking about making a will, etc., and the possibility of this getting contested, how do you kind of make this robust, right? Few tips from the experience that, me and my, colleagues have had in this space is that there are 2-3 things that you can do. One, of course, while I did make the statement saying that don't consult a professional, you can do it on your own. Having a legal consultation or a professional consultation with respect to getting a will actually ensures that the will is pretty much robust to kind of get it done. Second, you could also have a video recording of your will. What I mean by video recording is you don't need to get professional setup. Just get your phone camera, read out the content of your will, let your witnesses sign, you sign it. That becomes a legally valid evidence. And courts have upheld such evidence to say that if your will get contested, saying that this is a forged document or not, you are actually reading it out and it's your video, right? As long as it's not tampered, that becomes a valid proof.
Understood.
Another aspect could be to say, have a doctor's certificate. Basically, on the day of you signing the will, one of the reasons where the will can get contested is to say that you're not of sound
mind.
And a doctor's certificate validating or certifying that you are of sound mind on that particular date is something which can go as a proof should your will get contested, right? These few things really help. Registration is another aspect that you could look at.
For the sake of real estate.
For real estate, and more so if families have lost the will, they can go to the sub-registrar's office and pull up a copy, and it's as good as original.
Correct.
Right?
Which could have happened to you if you had such a will existed.
True.
And your nominees didn't keep mum.
So basically, you need to have a list of your assets, communicate that to the family. You have a list of, if you have opened a term insurance policy, your family needs to know that these policies are in place, right? And that becomes the segue for them to really, kind of say what asset that needs to be chased. And
Correct.
yeah.
See, that's the most important thing when you run the right thing by investing and buying term insurance, etc. But not telling your family about where things are and what the content of it is. I think it negates the whole idea of buying the term insurance in the first place.
Exactly.
It puts them into more hassle, or actually worse, puts the entire funds in limbo.
Correct.
I wanted to ask you on that front. How much time do you have to claim life insurance and term insurance after the demise?
So there is no timeline.
Oh, there is no timeline.
So essentially, if let's say it's been 10 years that my father passed away, if I today found a term insurance in his name, I can go to the insurance company and claim it today also. There is no exact timeline around it. But essentially, claiming term insurance is also the easiest of the procedures that one has to go as a family after the demise. It requires very less documentation. If there is natural death, probably only the doctor's certificate, death certificate, along with the reason of death, doctors, any treatments which were going on, those documentations may be asked. And that's sufficient enough to file for the claim. In case of an accident, the FIR or the accident report, all of those details are required along with the claim for the term insurance. Insurance companies are required regulatorily to be able to settle the claims within 30 days.
30 days.
Of all documentation that a consumer needs to provide to the insurance company. Okay. There are companies who are performing on days basis, hourly basis. There are companies who are now giving claims within 6 hours, 4 hours of all documentation being done.
Not bad.
There is only one catch. If one has taken a policy today and if the death happens in the next few years, there may be certain investigations which may get triggered by the insurance companies. That also has the deadline of overall 90 days that an insurance company has to complete all of that investigation and to be able to disburse the claim.
Understood.
So the maximum that a consumer may have to wait is 90 days after they have given all the documentation related to the claim to the insurance company.
Got it. What I can see is that 3 people that you should never lie to is your doctor, your lawyer, and your CA, right?
Maybe your insurance company as well.
Yeah, absolutely. So that you don't get disqualified in terms of the claims. It's odd how we often don't talk about death that much. It's scary, it's uncomfortable, and it's definitely not something we're ever ready to deal with. But talking about it can help with lifting an additional burden when you're no longer there. Thinking about and planning for what happens after you're gone may be gloomy, but it's also a kind and sensible thing to do. Kind for the people who are expected to go on without us. Writing a will and sharing our wishes can help our loved ones get through an impossible time with one less thing to worry about. Let's be more open to talking about this. That's how we can take care of our families even after we're gone. Thanks for watching.